Dear Airsoft enthusiasts, my name is Laurențiu Zanfirescu and I am the acting chair of Western Australia Airsoft Club. A concern raised by the Labour Party following their filibuster of the WA Airsoft Bill was that the bill does not implement the Law Reform Commission's model in regards to airsoft. In this video, we will look at how the WA Airsoft Bill differs from the LRC recommendations. For those that are not aware, in October 2016, after 2.5 years of work, the Law Reform Commission has published the final report into the review of the WA Firearms Act. The Commission produced 143 recommendations, out of which, as far as we are aware, the current Labour government has implemented none, almost 4 years since the report was issued. This inaction has great implications to the sport of airsoft because, should at least the recommendation related to the definition of a firearm have been implemented, airsoft markers would most likely not be classified as firearms. The current definition of a firearm in layman's term is anything that can shoot anything, even a Nerf gun. Yes, you heard that right. Part of the last firearms amnesty, we have surrendered Nerf guns, and WA police took these firearms into custody for destruction. However, they did not request all the retailers to take all these illegal firearms off their shelves. The Law Reform Commission report recommends changes to the definition of a firearm, specifically to the effect it can have: death or serious injury. The muzzle energies commonly encountered in airsoft, such as the one prescribed by the WA Airsoft Bill, have been determined based on ballistic testing conducted in the UK, and those energy levels have scientifically been determined not to be able to penetrate skin. This limited injury effect would quite certainly take airsoft markers out of the definition of serious injury. To further support this argument, the following energy levels have been adopted by various countries as the limit between an air gun and a non-regulated item. For reference, the regulated muzzle energy for paintball in Western Australia is around 12 joules. As far as we are aware, those countries that use the projectile damage level as the criteria for classifying an item as a firearm or as an air gun, none has used a muzzle energy lower than 5.7 joules. Airsoft is significantly below this value. However, this opportunity of regulating firearms by their damage level potential and the likely exemption of airsoft from the Firearms Act was lost. Therefore, let us proceed and understand how the WA Airsoft Bill differs from the LRC recommendations. And first, we would like to note that the Law Reform Commission only makes recommendations. These are not prescriptive requirements that need to be implemented ad literam. Furthermore, in some cases, the recommendations seem to have only been made from a negative risk perspective, and the implications to making the sport extremely unaffordable or unattractive do not seem to have been considered alongside with similar WA legislation currently in place. There is not much to comment regarding the first paragraphs of the first recommendation. Public safety has been one of the objectives of the bill. Airsoft venues will require the approval of WA police in a similar matter as to paintball fields. The recommendation asks for limitations on the performance of airsoft markers, and the WA Airsoft Bill has used the same values as the UK. The Labour Party raised the question why the proposed values were chosen when there are countries with lower energy limits. We will be releasing a video on the subject of injury risk, and when it becomes available, we will add a link in the description below. The bill also addresses the projectiles used, placing limitations on materials of construction, size and weight. Regarding Recommendation 2, the WA Airsoft Bill proposes similar arrangements, however not identical in all cases as to how paintball is regulated. The age limits for airsoft are the same as for paintball. The third recommendation addresses the pellets which shall be non-metallic. This has been addressed by the bill, plastic or biodegradable pellets. The second item, the Commission's recommendations to prohibit gas-powered airsoft markers, has not been implemented. For this, we will be releasing a separate video on gas-powered airsoft markers, explaining why the recommendation has not been implemented. When it becomes available, we will add the link in the video description below. The fourth recommendation was implemented by the WA Airsoft Bill. It is debatable whether partially or completely. The bill provides for mandatory coloration of airsoft markers, however of a non-permanent nature that can be removed at an approved venue. To further discuss this, we will be releasing a separate video on the appearance risk of airsoft markers, explaining why the recommendation has been implemented the way it has. When the video becomes available, we will add a link in the video description below. The fifth recommendation is inherent to the Firearms Act and regulations. The WA Airsoft Bill does not require any additions to implement this recommendation, nor provides provisions that go against this recommendation. The sixth recommendation is implemented almost word by word. The Airsoft Bill proposes the same wording as for paintball under the current Firearms Act. The seventh recommendation is also implemented. Recommendation 8 is for WA Police to consider when issuing approvals and does not sit at the Act level. As such, a provision is not made for paintball fields or gun ranges. Recommendations 9 and 10 are inherent to the Firearms Act and regulations. The WA Airsoft Bill does not require any additions to implement this recommendation, nor provides provisions that go against these recommendations. The first paragraph of Recommendation 11 addresses modifications to the functioning of an airsoft marker. This recommendation has been implemented through the same wording used for paintball by the current Firearms Act. Regarding identification marking and coloration, these are specific penalties under the current Firearms Act and regulations. The WA Airsoft Bill does not require any additions to implement these recommendations, nor provides provisions that go against these recommendations. In conclusion, if the Labour government would have implemented some of the recommendations of the Law Reform Commission's report, in particular changing the definition of a firearm to make it specific to its lethal or significant injury capability, airsoft would have most likely been exempt from the Firearms Act. The WA Airsoft Bill implements most of the recommendations of the LRC report, or in some cases is not required to implement them, as they are already built within the Firearms Act and regulations, and the bill does not propose anything contradictory. The two items where the WA Airsoft Bill makes a departure from the recommendations of the LRC report is the use of gas as a propellant and the non-permanent mandatory coloration of airsoft markers. We would like to advise again that these are simply recommendations and are not required to be implemented ad literam in legislation. We will be releasing separate videos addressing these two deviations. My name is Laurentiu Zanfirescu and I am the acting chair of Western Australia Airsoft Club. Thank you for watching and sharing our content.